gentleman, state's final closing.
The defense said that Marcy blames everyone else. It's never her fault. Well, ladies and gentlemen, that is the exact description of the defendant. He actually wants you to believe that everyone else is to blame for what happened on September 4th but him. If you remember the lesson that Ms. Ryan was teaching on September 4th, you can see the bullet holes to the right, and then there are the dots connected on the left. She was teaching about connecting the dots. And think about these dots related to what the defendant wants you to believe. None of the people that the defendant wants to pin it on had all of the information. None of them had all of the dots. He blames good people at the school system who were just doing their job. Lisa Butler knew Colt as an emotionally unstable 14-year-old whose dad would not pick him up during an anxiety attack. When she received the email about Colt asking about school shooter drills, that's the context she had. She did not know that Colt had a rifle in the corner of his room right next to his school shooter shrine. And as a side note, Lisa Butler never testified that her and Colin met about figuring out what to do about Colt's 8th grade year. You remember, Lisa Butler was very clear. The defendant never told her about Colt missing 8th grade. She didn't find that out until Debbie told her. The defense also wants to blame school administrators for not sounding the alarm immediately. D. Martin had never met Colt before. This was his 4th day in classes, 5th day at school. So when she got information that he maybe had a gun in a heavy backpack, no one had actually seen the gun, she didn't have any context. She didn't know that he had gotten an AR rifle for Christmas. She didn't know that he had been investigated for a school shooter threat. She didn't even know about Lisa Butler's phone call with Marcy until after it was too late. And the grossest shifting responsibility is trying to accuse his own daughter, Jenny, of wrongdoing. In the same breath that he wants you to believe he kept the guns in the closet, he also wants you to believe that Jenny is at fault because she looked in his room that morning and didn't see the gun. This is an argument of desperation, but it's not surprising coming from the defendant. Jenny was the one who encouraged the defendant to talk to adults about Colt's mental health. They talked about him actually securing the guns. And the defense says she didn't call the defendant, but she did. She called the defendant at 8:30 that morning. We don't know what was said, but we do know that the defendant immediately identified what poster Colt had around the rifle when he was talking to Investigator Smith. Jenny is not to blame. The defendant is. The only person who knew every single dot, the only person who knew how much access Colt had to firearms and ammunition is that man. And the only person who knew exactly what Colt was capable of is the defendant. He was the one person who could have connected all the dots that pointed exactly at what Colt was going to do. And he was the one person who could have simply taken the rifle away, and he never did. Ladies and gentlemen, we already live in a world where our teachers, our students, our law enforcement officers have to train for the possibility of an active shooter coming to their school. It is preposterous to say that they are the ones to blame for what happened on September 4th. It is insane to say that they are more culpable than the man who armed Colin Gray. The individuals at the school only had minutes to connect the dots. The defendant had years, and he did nothing. want to talk about the computer that was in Colt's room and the person he was texting. Well, the defense knows that hearsay of Colt isn't admissible. They know that we can't prove that the defendant knew what was on Colt's computer, so that's not admissible. It is just an argument to try to distract you from what the actual evidence of what the defendant knew was. And then they want to insinuate that Marcy is really the one to blame. That's not an argument based in law or fact. Did Marcy Gray and her addiction cause more chaos in the lives of the Gray children? Absolutely. And that's why Jenny, by her own choice, doesn't have contact with her mother. But she's not charged because she did not commit actions that constitute a crime. You can see it in the indictment. The defendant is charged because he had custodial responsibility and he gave Colt access to a firearm and ammunition. For the custody part, you can see it on these calendars. The blue shows when Colt was living only with the defendant. The purple are those 2 months and a few days where he was living only with Marcy. And the green in 2024 is the few weeks where they all lived together. Of the last 22 months before September 4th, over 18 of those months, Colt spent solely with the defendant. The defendant had custody. The defendant had the ability to take that gun away. This case is not about who is the worst parent. It's about who armed Colt and who enabled him to commit the crime that he did. And it was that man. And again, listen to the judge about what the law is, because the defense is misstating it again. We do not have to prove that the defendant knew his son was going to commit a school shooting on September 4th. And let me be very clear about this. If Colt Gray had sent the defendant a text message saying, "I'm about to go shoot up a school," or if he told him, "Hey, I'm going to go shoot up Appalachia today," then he would be charged with malice murder because he gave him the firearm and ammunition that let him do it. He would be charged as a party to a crime. And that is a completely different charge. He is not charged with knowing that he was going to commit a school shooting. He is charged with having sufficient warning that Colt would harm someone. If you find that the defendant had sufficient warnings about his son, sufficient warnings that he would hurt someone, that the defendant consciously disregarded that risk by giving him access to ammunition and a rifle, and for the second-degree murder and involuntary manslaughter, if you find that the deaths were reasonably foreseeable, then the defendant is guilty of the crimes charged. Those points are your focus. Not Marcy, not the countless people that the defendant wants to blame, and certainly not the dark web. Those three things are what you talk about in the jury room. Those three things are what you need to find the defendant guilty. So let's honestly seek the truth and talk about all the reasons why you, the jury, know that the defendant is guilty of these crimes charged. First, let's go through the warnings the defendant received that made him aware that his child was a risk to hurt someone. There are three categories of warnings we're going to talk about: Colt's mental health, his violent tendencies, and then red flags. First, the defendant knew that Colt's mental health was deteriorating, and he never got him help. The defense talks about how the defendant was trying his hardest. He did everything he could to get him help. He thinks he should be absolved of guilt because he filled out one form a day and a half after he received it. No. Ladies and gentlemen, opportunity after opportunity went by for the defendant to get Colt help. But he didn't. And he actually actively kept him away from the resources that could help him. And this is consistent with the defendant's whole persona. As Mr. Smith pointed out to him on Friday, Every lie he tells makes himself look better. It's not a misstatement, it's intentional. He is a narcissist who has created this facade that he's a good father. And if he puts Colt in counseling, that facade comes crashing down. We can see that as far back as October of 2021, Colt had counseling sessions in Fitzgerald. Remember? DFACS had signed him up with Raymond Dean, and he had 1 or 2 sessions. But when Shonda Goolsby came out for a home visit, the defendant was at his truck packing up. And remember what he told her? He doesn't like DFACS involved in his family. And he packed his family up, and he moved to Jackson County. There were resources available, and he took Colt away from them. On May 21st of 2023, that's when Jackson County came out to investigate Colt for threatening to shoot up a school. On June 9th, 3 weeks later, the defendant tells Michaela Anderson, Colt doesn't need counseling. He is angry at his mom. He's being bullied, according to the defendant, and he's suspected of threatening to shoot up a school. He clearly needed counseling. But the defendant lied and said he didn't. Again, not getting the resources he could have. 2 weeks later, in a month after the Discord investigation, they sign a lease in Bexar County, and they move. Colt gets on the radar in Jackson County. The defendant takes him off of it. Colt then moves back to Fitzgerald in the summer of 2023. And his grandfather calls the police on him October 3rd. And what happens on October 4th? The defendant comes and gets him and brings him back to Bexar County. Gets on the police's radar. He moves to another county again. And remember, October 4th was 1 day before he had counseling scheduled again in Fitzgerald. Again, he doesn't get the resources he needs. Then we have October 30th of 2023. Miss Pierre Charles comes out to the residence to do a home visit, and the defendant lies to her and says, we're doing counseling at Bexar Ministry Village. Well, you heard Scott Dakin, their director. They never did counseling there. The defendant even admitted it after hearing from Scott Dakin. They never did counseling there. He must have just made a misstatement. No, he lied, again, to get DFACS out of his lives and them off their radar. And then one of the clearest derelictions of his duty to his child, he did not put him in 8th grade. He was out of school for an entire year. Remember at Jefferson Middle School? He was on Carol Ann Knight's radar. They had counselors eating lunch with him. They had the school success coach constantly emailing the defendant to try to get in touch with him. And he never responded. That's why they knew his name. Not like he says because he was up there all the time, but because they had to try to get in touch with him so many times. He was on Jefferson's radar. He was getting resources. And the defendant, again, took him out of school, took him off the radar. In the defense, remember what they said? The defendant believed that Marcy had threatened to kill Colt and that Colt knew that. Well, if you believe that, something that traumatic has happened to your child, you get them counseling. You don't keep them out of school for an entire year, isolated, at a time when he believes his mother has threatened to kill him, at a time when his mental health is deteriorating. The defendant isolates him. He leaves him at home. From October to May of 2022, or May 22nd of 2024, every day he leaves him at home. Look at this board. Every time Colt gets on the radar, every time services are available to him, the defendant takes him off and moves him. Let's move to the summer of 2024 and the beginning of 9th grade for Colt. At this point, his mental health is rapidly declining, and the defendant continues to do nothing. On July 20th of 2024, Marcy texted Jenny, Colt had a horrible panic attack last night. And both she and the defendant testified about this. Colt asked him to call 911, was crying, was upset. They didn't. They didn't call 911. They didn't go take him to a doctor. They didn't get him help. The defendant did nothing other than leave the rifle in the room. Fast forward to August 16th. The defendant reached out to a counselor. Finally, maybe he'll get Colt help. Dawn Crook. And this is how he described Colt to her. He needs help, anger, anxiety, quick to be volatile. I don't know what to do. He admitted his son needed help and that he didn't know what to do. Yet, he did not follow through. He did not actually get Colt help. Instead, he lied again. When Dawn called him, he didn't pick up. He was just at his house, but he lied and said he was in the field. Instead, he just sent a screenshot of Dawn's response to Debbie. Why? Because everything he does is for show. He wants to look like a good dad. Hey, Debbie, look, I'm getting Colt help. He wants to appease her so she'll keep giving him money. He doesn't actually want to get Colt help. If he did, he absolutely could have. The defense points out that today still, we don't know what's wrong with Colt. Well, we don't know what's wrong with Colt because the defendant never got him evaluated. If he had, we would know what was wrong with Colt. However, the defendant isn't guilty of these crimes just because he didn't get Colt help. That doesn't make him a criminal. It makes him a bad parent, sure, but not a criminal. The defendant is guilty because he's clearly aware that Colt needs help. These text messages, these researching that he's doing, he knows Colt's mental health is deteriorating. But he still leaves the rifle in the room. That's why he's guilty. We fast forward 10 days. Now we're at August 26th. Colt has another severe anxiety attack at school. Does the defendant pick his kid up, his anxiety-ridden, crying, upset child, and take him to Dawn Crook's office? Or Advantage, that you heard him testify he knew was open every day? No. He leaves him at school. And then the next day, Colt is absent from school. Colt is home alone the day after an anxiety attack with the rifle still in his room. The very next day, August 28th, Colt told the defendant that he had no control over what voices told him to do. I have to kind of dance around the inconvenient truth at times. I have no control over what these things say and tell me to do. A day after, or 2 days after a severe anxiety attack, he's talking about voices, and he still leaves the rifle in the room, ladies and gentlemen. 5 days later, on August 31st, the defendant had one more opportunity to just do the right thing. Get your son some help. But once again, he failed his son. He ghosted Marcy, and instead of taking Colt to Advantage on his own, he just went within 2 miles of Advantage. He went to an ATM and got the $400 that he had lied to get Jan to send him out. And then they went to the Guitar Center and bought some stuff. And remember this, the defendant knew Colt was a cutter. He testified to that. He said he knew as far back as when Colt was in Fitzgerald. And you heard Vicki Lee testify. If they had known, if when Colt presented, if he ever presented, and they had known that he was a cutter, they would have hospitalized him. You know what that means? We wouldn't be here today because this tragedy would have been prevented. Ladies and gentlemen, the defendant absolutely knew he could have and should have taken his son to advantage on August 31st. That very Saturday of August 31st, he texted his sister Jan, "I hope everything is going good for you. I need a favor if possible. I'm a couple dollars short on rent and wanted to see if I can borrow some money, and I will Zelle it. Back to you Friday. I'm short because of co-pays for doctors for Colt. I think I'm going to have to check him in a place so they can try to help him. He had a full-on panic attack at school Wednesday. So I'm trying to get him into a psychologist in Athens." He's talking about Advantage on the Saturday he is supposed to take him to Advantage. And don't buy his lie that the plan was Project Aware, because he signed the Project Aware form 4 days before this Saturday. He's telling Jan, no, the plan is still Advantage, but he doesn't take him. This text also highlights the absolute reckless disregard the defendant had. What it shows is the defendant's willingness to not only use Colt's deteriorating mental health for his own benefit, but it also his willingness to lie for his own benefit. Remember what investigator Gilliland testified to. The defendant never paid a doctor's copay for Colt. Never took him to a doctor. The defendant even admitted that on the stand, that he lied to his sister. The only doctor he ever paid for was that medicine will, so he could get his own medicines. Weekly, he would go to Medicine Will and get his medicine and pay $90. He was willing to go to a doctor to meet his own needs, but he was never willing to get his son help. And he was never willing to take the rifle out of the room. The next warning the defendant received was Colt becoming more and more violent in the months leading up to September 4th. Colt has documented behavioral issues going all the way back to first grade, where he would kick and hit students at least 2 to 3 times a day. And even if you believe the defendant that he had no idea about that, there's no way that behavior wasn't also going on at home. In 6th grade, another sign of violence is that Colt actually searches how to kill my dad and abuse. He also broke windows and cut a couch in Fitzgerald. And when he moves back to Barrow County with the defendant in October of 2023, he becomes physically aggressive with the defendant. Jenny, in her testimony, detailed fistfights between the two of them and described how Colt would cause holes in the walls of the house. The defendant, even in his interview with Special Agent Ward, acknowledged that things were getting worse, and his text messages show that. Sometime in June of 2024, Colt threw a screwdriver at the defendant. And it wasn't this story that he's made up where Colt got frustrated and just threw the screwdriver across the room. Listen to the text. The defendant texts Colt, "Okay, question I have is this. Did you tell Mamu that you had the screwdriver in your hand for self-defense? Please tell me the truth, because we both know I wasn't even looking at you when you threw it at me." Again, he's lying to make the situation look better. And one of the biggest warnings the defendant received that Colt was a threat to hurt others, was a threat to use his rifle, was when he got into a physical altercation with Marcy with the rifle. Now, despite the defendant's new version of his story that he told y'all on Friday, this is what he told Investigator Smith.
No, she said, hey, she went down in there and said, you need to get your shit straight, go to school, and we need you to just get these guns put up, because what she said.
What did he say?
And that's when they went from bad to worse. And she said she was going out of his bedroom and he pushed her, and she hit the door of the wall and the side of her head. And I'm like, okay, I'm on my way home. So, yeah.
Remember, this is just one day after Colt told the defendant that the blood would be on his hands. That was August 14th. We're at August 15th, and he gets in a fight with Marcy with the gun. And you know the defendant believed Marcy, that Colt was out of control, and that Colt was responsible for this, because he immediately started, as he termed it, researching where to take Colt. He searched for where do I take my son for anxiety on August 15th, after the altercation, and troubled teen options and child psychologists on August 16th. That's also when he reached out to Don Crook. Colt was so angry about the thought of someone taking his gun away that he pushed his mother. There's no legitimate reason why Colt needs the gun in his room. The defendant acts like this is their escape, this is their bond, this is how they get together and hang out. But the reality is they went hunting one time in 2022, and they went to a gun range twice in 2024, with the last time being in March. Colt doesn't need that gun in his room. They're not bonding over it. The defendant testified that the rifle never came into play with Colt's arguments, not until it did with Marcy. He essentially said, but if it had been involved, sure, I would have definitely taken the gun away. Listen to what he is saying. He would have taken the rifle away once Colt used it. Guns kill people. Once Colt uses the gun, it's too late. The defendant does not get absolved of guilt because he would have taken the gun away if Colt had shot someone with it. He doesn't get absolved of guilt because he's hopeful that Colt won't use it. He is guilty of these charges because leaving the rifle in the room caused the death of 4 people. Now, the final warning we have is the red flags. And again, we don't have to prove that the defendant had sufficient warning that Colin Gray would specifically become a school shooter. That is not what the law is, just that he would hurt someone. But in addition to the deteriorating mental health, the escalating violence, the defendant did have 3 huge red flags that specifically pointed at Colt becoming a school shooter. Of course, the first one is the fact that law enforcement came out to the defendant's residence in May of 2023. In the context of Colt previously threatening to murder his dad on a computer, law enforcement is coming out to talk to the defendant about another threat of murder on a computer. And regardless when the defendant found out about this, he absolutely knew it before May of 2023. The defendant claims that the Jackson County investigator said that he believed it wasn't Colt. Again, don't listen to his lies. You didn't hear that on body cam, and you certainly didn't hear Investigator Miller testify to that. And you know that that didn't happen because of what the investigator told, what defendant told Investigator Smith. Remember when they were talking about this incident? The defendant said this was a red flag to him and that he took the computers away. If he believed that Colt had nothing to do with this, why take the computers away? And yet, he still bought his son a rifle 6 months later on November 17th. Ladies and gentlemen, the Friday before Jackson County came out to his house was Colt's last day of 7th grade. August 14th of 2024 was his first day of school since that school shooter threat. And this is what he does that morning before school starts. He texts his father, whenever something happens, just know the blood is on your hands. This isn't a text about Marcy. That's another lie he spent a year and a half coming up with. At no point in this entire text thread where he's talking about the defendant driving off a cliff and how he twists lies does he ever talk about Marcy. This is a threat, and the defendant knew it. This was another dot that the defendant had that, when connected, pointed directly at Colt being a danger. And yet, the rifle stayed in the room. Another red flag is Colt's paranoia about his teachers. He texts Marcy on August 28th, "There are people after me and I don't like it, my teachers. I feel as if they're plotting against me. Somehow I feel like they'll hurt me." And we know that the defendant knows about the teachers because as soon as Colt texted Marcy this, she texted the defendant and said, "He just told me about his teachers." The defendant also told Investigator Smith about the teachers and said specifically that Colt thought math teachers were out to get him. And remember Miss Greer's class? She was Colt's math teacher. That was the class that he couldn't get into when he came out of the bathroom. Not only does Colt now have the means to commit a school shooting, but he has a target that he has identified to his dad, math teacher. And then the last huge red flag is obviously the school shooter shrine. Colt wanted his dad to see this shrine. It is on the most prominent wall in that room. It is on the wall right across from the bedroom door. This door is 12.2 feet from that wall. Every time the defendant walked into that room, this is what he saw. Every time the defendant walked out of the bathroom, this is what he saw. And on September 4th, when he walked into the room to see if the rifle was there, this is what he saw. Were you in the back? This is what he saw. You can read the headlines. You can see that these are all of the same person. Now, he downplayed how many pictures were on the wall. He said it was just one. But he did finally admit on cross-examination to Mr. Smith that he knew who it was. He knew it was a school shooter on his wall. And it took him a while to admit that because it's really bad evidence against him. But it's also something he specifically tried to cover up. He initially admitted to Special Agent Ward that he knew who the picture was of. He said it was the last school shooter. That's what he told Special Agent Ward. But then he realized he's being investigated. And at that point, he goes into cover-up mode. He told Jenny to specifically lie about knowing about the school shooter shrine. And you know how we know she's telling the truth? Because right after he tells Jenny to lie at the treehouse, he walks from the treehouse to talk to Investigator Smith. And when he talks to Investigator Smith, he lies and says he doesn't know who was on the wall and that Colt never told him.
Did he so he never told
He
you?
never told me who that was.
Never did?
He never did. He just lies.
He lied, and he told Jenny to lie. And one of the most accurate things the defense said when they were direct examining the defendant is that the defendant would have taken the shrine down if he had had time. But he didn't have time. He pulled into his driveway at 12:27 on September 4th, Less than 5 minutes later, law enforcement is already out of their car going to bang on his door. And he heard sirens well before that. He didn't have time to cover anything up. He had time to come up with a lie, and that was it. Don't believe the defendant's downplayed version that there was just one picture on the wall. Colt had pictures of Nicholas Cruz on his wall dating back as far as April 15th of 2024. And the particular version of the shrine that was there on September 4th had been there for months, according to Jenny, 3 to 4 months. And the photos that Colt took of his shrine corroborate that it had been there for a while. When you flip the mirror images, you can see that the photo that was taken on August 9th, August 28th, and September 2nd looks exactly like how the shrine was on September 4th. It had been like that for months. It wasn't just one picture, it was 12 pictures and 4 articles. Teenagers have athletes on their wall. They have movie stars. They have musicians. They don't have mass murderers of children tacked all over their wall. Colt was glorifying a mass murderer for months, a mass murderer of children for months, and the defendant left the rifle in his room. The defendant claims he didn't see this coming. Any reasonable or even unreasonable person would walk into that room, see that, and know exactly what Colt was capable of, and would take the gun out of his room. At the moment a reasonable person saw this shrine, that is the moment they would 100% connect the dots and know that it was Colt who made the school shooter threat. It is when they would connect the dots and know what he meant by the blood is going to be on your hands. And is when they would know who the target was going to be, his math teachers, his school, just like he threatened online and just like his idol, Nick Cruz. The next thing the state has to prove is that the defendant gave Colt access to ammunition and rifles. And, the defense talks about, well, it's not illegal to keep your guns and your rifles unlocked. Sure, there's no specific law in Georgia that says every single person has to put their gun in a gun safe. But there is a law that says you can't not secure your guns if it is a gross deviation from the standard a reasonable person would do. And that's what the defendant did. He gave his son access to a firearm, and that was a gross deviation from what a reasonable person would do. And for the ammunition, we know the defendant was the one who purchased the actual ammunition that was used in the shooting. He purchased it on June 7th. He purchased Lake City Winchester full metal jacket, and that was the ammunition that Colt used and that Colt had left on September 4th. Colt also took pictures of the ammunition he was allowed to have in his room. And when law enforcement got to the defendant's house, more ammunition was just in an unsecured box in the laundry room where Colt often slept. The ammunition was not secured, it wasn't separated from the weapons, it was just out and all over the house. And just like Colt can't buy a firearm, he can't buy ammunition. He's under the age of 18 and he can't get it without the defendant's help. Without the defendant getting him ammunition, this would not have happened. On August 11th, Colt sent the defendant this text message. Could you stop by Academy and pick up a 150 round pack of 5.56? If they don't have it, or if they don't have that, or 5.56, 223 will do. And then he follows up on August 16th, hey, if we can get 150 rounds, that's fine, but could we get at least 50? These texts show more than just that the defendant buys Colt ammunition. It shows another red flag. Another warning that should have triggered the defendant to put the gun up. Why is Colt asking for 150 rounds of ammunition? The defendant claimed on the stand it was to go to a gun range over the holiday weekend. Well, they didn't go to a gun range over the holiday weekend, and there are no text messages showing that they were planning that or that was ever something that they were going to do. But also remember when they went to the gun range on March 29th, the defendant did buy ammunition on March 28th, right before. He went to Academy Sports and bought Hornady Custom 223 rounds. He bought 20 rounds to go to the gun range, not 150 rounds. And he did it without Colt asking him for it. Colt only started asking him for specific rounds of ammunition when he was building his plan to commit a mass shooting. Colt did not need 150 rounds to go to a shooting range. Any reasonable person would have connected the dots and realized Colt wanted ammunition for an entirely different and evil reason. We've also proven he had access to the rifle. First, the rifle definitely wasn't in the defendant's closet like he claimed on the stand. This was another lie to make himself look better. Initially, he actually admitted to Special Agent Maddox and Ward exactly where Colt's gun was supposed to be on September 4th.
I said, hell, it's not him. I said, all the guns are accounted for. They're in my closet. And I said, except for the one Colt put that laser in. I said, I'll call you in a minute. So as soon as I got here, I opened that door, Fox News, I left the TV on, and sure enough, there's Appalachia High, and I'm like, Jesus Christ. I go down to his bedroom, and I just stuck my head inside there, and there's his two guitars, and it's laying over there in the corner, and it's not there.
The rifle was supposed to be in the corner of his bedroom, and it wasn't. Not in the closet like he said on Friday. But that makes him more guilty of a crime. So he claimed on direct examination on Friday that he kept the rifle in the closet. He said, I quote, I moved everything out of the way. Like he was, I think he made hand motions at some point on cross, that he's moving everything out of the way to go check for the rifle in his closet. But during cross-examination, when confronted with the picture of the closet, which clearly does not have everything thrown out of the way, he's like, oh no, I just pulled the blankets apart and then they fell back down. Ladies and gentlemen, the thing is, just keeping the rifle in the closet isn't much better. Colt still had access to it. It wasn't secured. But he doesn't have a gun safe, so it's the only lie he's got. So he tries to make himself look better by saying it was in the closet. Don't let the defendant pull you into his fantasy world. You know Colt kept the rifle in his room based on all the photos Colt took of the rifle in his room, based on the defendant's own admissions on September 4th, and based on text messages that Colt actually sent the defendant. On August 15th, when they're talking about this altercation with Marcy, Colt says, tried to grab my gun. He didn't say your gun, Dad. He said, my gun. And then he says, I don't know, she backed me into my room and started talking about, are you going to get your gun? Even though I wasn't. And then she grabbed it. My room. Marcy grabbed the gun when she was in Colt's room. He's telling his dad, the defendant, my gun is in my room. The defendant knows where it is. That's where it stays. That's where it's always stayed. The defendant wants you to believe that he didn't need a safe because he and Colt had a trust pact, like a blood oath, and Colt would never use the firearm improperly. But he didn't believe that. If he had believed that, he wouldn't be looking for gun safes. And if he had believed that, he wouldn't have told Marcy that he was going to put up the guns.
It's been like that, like our guns have always been.
But what did Marcy ask you about the guns? What did she say to you about the guns?
She just said after the confrontation she had with Colt was like, you need to put them up or get rid of them. And I said, okay.
The defendant wants you to absolve him of guilt because he was about to get a gun safe. He just needed $78 more. Don't believe the defendant's lie. In the month of August, he brought in almost $9,000. He got 5 paychecks for $1,429. He got Zelle after Zelle from Jan and Deborah, and that totaled $8,882. He certainly could have found $78 to buy a gun safe, but the truth was, it wasn't his priority. His priority was getting accessories for Colt's gun. It was getting the sight, the iron sights, the rails. It was getting a school shooter vest that looked exactly like the one Nick Cruz had in his photo. It was getting a half mask that looks like the one he has in that photo. And the truth is, if securing the gun had ever been a priority for the defendant, he could have just used a gun lock that came with the guns he bought. You saw Sarah Van Holm put this in the rifle. It took 10 seconds. 10 seconds would have prevented all of this. But he didn't bother. Finally, for the second-degree murder and involuntary manslaughter charges, the state must prove that the defendant was the proximate cause of the deaths of Mason, Christian, Coach Aspinwall, and Miss Earmy, that their deaths were reasonably foreseeable. And again, the defense is misstating the law. We don't have to prove that the defendant could foresee exactly the way Colt was going to murder people, that he was going to get on a bus with a long gun. We just have to prove that the deaths were reasonably foreseeable. And the board over there, that's enough. You see that, you know what he's going to do. But there's more. The defendant knew that Colt had committed a mass shooting even before the news broke that there was a mass shooting at Appalachia High School. At 10:55, Jenny texted him, "I'm scared." The only time he had talked to her was at 8:30 after she had gotten off the bus. Yet, he doesn't say, "Why are you scared? Everything okay? What's going on?" He says, "It's going to be okay." Because he knew exactly what she was scared of. After he heard that there was a shooting, but before Colt's name was released, the defendant knew for sure his son had committed this crime. Everyone who had a child at Appalachia High School was leaving work and going to the school because they had heard about the shooting. Remember Jackie Garcia? She ran across the street after telling her employer, "I'm going to go check on my daughter." We didn't just have her testify for emotional effect. Her testimony had a purpose. The body cam we played through her had a purpose. It showed that her and parent after parent came running to Appalachia High School. They were terrified. They were wondering if their child was hurt. But not the defendant. He told Special Agent Ward that he left the job site as soon as Colt texted him, "No, I love you and Coley and Jenny." But that text was at 10:03. He didn't leave the job site until 11:18, an hour and 15 minutes later. He knew what Colt was about to do, and he just continued to work. He didn't call George Clackham until 11:07 to tell him he was leaving. He lied to George and said his son broke his arm. And do you remember his explanation on the stand? He needed to tell George something that was serious to get his attention. Are you serious? Are you joking me? Jenny texted the defendant at 11:01. 3 people are dead at the high school. You can see under red, the defendant read that at 11:01. So at 11:07, when he's calling George Clackham, he knows 3 people are dead at the high school. Something serious would be, hey George, there's a shooting at my son's high school. I've got to go. He lied to George for one reason. He knew his son was the shooter. He did not need to hide the fact that his child was at a school where a shooting had occurred. He needed to hide the fact that his son was a school shooter. So he lied. Instead of going to pick up Jenny, who was begging for him to come get her, who was scared, he goes to QT and gets a drink, and then he goes home to confirm what he already knew, that his child had murdered people. And even more chilling, even more evidence that he knew what Colt had done, is that as soon as Jenny told him that 3 people are dead, at 11:01, she told him that. And you know what he never did again? Until police got there and he knew Colt was alive? He never texted or called Colt again. After 11:01, his last text to him was at 10:50. Hey, can you give me a quick call? You saw the texts and calls he was doing after he said, I'm sorry. It was constant. But never again after 11:01. Do you know why? He thought his son was dead or in custody. He knew he couldn't answer the phone. Not only was the shooting foreseeable, but the defendant knew he was responsible. You heard how Marcy researched Ethan Crumbly, a case where the parents of the school shooter were charged for not securing a gun. And you heard how Marcy clearly communicated that to the defendant based on their constant phone calls. You heard how the defendant lied to his boss to hide the fact that his son was a school shooter. And you heard how he made Jenny lie for him. The defendant not only knew what his son had done, but he knew what he had done too. Of the 2,000 students at Appalachia High School, only one set of parents suspected that their child was a school shooter. And only one parent had custody of that child and had given him the rifle and ammunition that he used. And that one parent was the defendant, Colin Gray. That is foreseeability, that is murder in the second degree, and that is involuntary manslaughter. Ladies and gentlemen, the defendant wants you to believe that this wasn't his fault, that he was trying his hardest, that being a single dad is hard. The defendant wants you to believe that he needed just one more day, and he would have taken that rifle away and everything would have been different.
I knew I needed just one more day. I think this would have just changed everything because I could feel it. I could see.
You can feel what?
Just his whole attitude change.
How?
The defendant had 292 days between the day he bought his son a rifle on November 17th of 2023 and the day this unspeakable crime happened. 292 days to take any number of heartbreakingly small steps to prevent this mass shooting. He could have not lied to Miss Pierre Charles the day she did a home visit and asked her to get him some help for his child. He could have not bought his son, who had been accused of threatening to shoot up a school, an AR-style rifle on November 17th of 2023. He could have put his son in 8th grade any day that school year so he had resources available to him. He could have called 911 the day his son had an anxiety attack and begged him for help. He could have locked the rifle in his truck the day Colt asked the defendant for 150 rounds. He could have sold the rifle back to Mike's gun room the day Colt told the defendant that the blood would be on his hands when something happened. He could have bought a safe and secured the rifle the day Colt used it in a fight with Marcy. He could have put one of those gun locks he had on Colt's rifle the day he saw the mass murder of children tacked on his wall. He could have answered the phone the day Don Crook called. He could have picked Colt up and taken him to any counselor the day that he had an anxiety attack at school. He could have taken Colt to Advantage Behavioral Crisis Stabilization Unit the day of August 31st. The defendant did not take any of these heartbreakingly small steps. And because he didn't, because the defendant consciously disregarded the very apparent and obvious risk that his son was going to harm people, Mason, Christian, Coach Aspinwall, and Ms. Earmy do not get another day. They do not get one more day. Because of the defendant, their families will never get one more day with them. Because of the defendant, every student and teacher in Ms. Ryan's class will not have one more day where they are not the victims of a mass shooting. One more day where they don't have to fear something like this happening again. Ladies and gentlemen, do not give the defendant one more day to peddle his made-up excuses for why he did nothing to stop this tragedy. Do not give the defendant one more minute of listening to his lies about how he did everything he could. Do not give him one more second of not being held responsible for what happened on September 4th. Ladies and gentlemen, we have done our job. It's time for you to do your job and find him guilty of all charges.